Good morning, Mr. Warren. Good morning. You're Valerie Hill. And will your client waive the formal reading of the indictment?
Your Honor. I don't think I put on the paperwork the interlock judge, but that's part of the plea agreement.
Okay. All right, Ms. Hill, in cause number 25 DCCR 0573, you're charged with a state jail felony offense of driving while intoxicated with a child under 15, and that's from March 13th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 2-year term in the state jail prison, but that would be probated. You'd be on probation for 5 years. Ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation, including having an auto ignition interlock device on your vehicle. Do you understand?
A quiet courtroom hums with tension as one defendant after another faces judgment. Valerie Hill pleads guilty to endangering a child while driving drunk, her voice trembling as the judge lays down probation and warnings. But beneath the calm procedure, a storm brews. Soon, the judge's patience will be tested by a man who can't stop lying about his own downfall.
Do you have one now?
Yes.
Okay, I was about to say you should already have one, and so that'll be part of your probation, at least for some amount of time as well. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection?
It's admitted. Is there any evidence that Ms. Hill's not competent?
No, Your Honor. We'll waive the PSL.
What kind of history, if any?
Absolutely none, Judge.
Okay.
Just go to my file.
All right, so Ms. Hill, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea. Waive the pre-sentence report, find sufficient evidence to find you guilty, and at this time follow the agreement that you made with the district attorney and find you guilty of driving while intoxicated with a child passenger. Sentence you in accordance with that agreement to a term of 2 years in the state jail prison, but I'm going to probate that. You'll be on probation for 5 years. You're ordered to pay the $1,000 fine and to follow all of the rules and condition of probation, including continuing with that interlock device until further order of the court, okay? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. And so this is for you, for this probation, this is for all practical purposes, your case here in court is over. And you'll be able to serve that 2 years while you're out on probation instead of in the state jail prison. And if you do everything correctly, you'll never be back in court. The other side of that, though, is if you violate any condition of probation, you can be brought back into court and you could be facing that 2-year sentence that you've agreed to. Do you understand? All right, you just need to have a seat here in the courtroom. Probation, she's sitting at that desk right there. She's going to call you up when she's ready to go over your paperwork. Okay? Yes, ma'am. Good luck. Good morning. Are you Christopher Morale?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
No, Your Honor.
Mr. Morale, in cause number 25 DCCR 0466, you're charged with the 3rd-degree felony offense of continuous violence against the family from February 8th of 2025. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am, I did.
And do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation, including entering and successfully completing an anger management program. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenors number 1.
No objection.
It's admitted. Is there any evidence that Mr. Morale is not competent?
Negative.
And as a condition of your bond, is it already, you should already have a condition that you're not to have any contact at all with Alonda Kelly?
Yes, ma'am.
Okay, so I want to make sure that you're still under that bond condition, that it will likely be a condition of your probation as well.
Absolutely.
So I want to, if you violate that and have any contact or communication with her whatsoever before sentencing, then I don't have to accept this agreement. Things could be much worse. Do you understand?
Yes, ma'am.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there. All right, we'll see you back at sentencing. Thank you, Mr. Parker. When did you smoke marijuana last? So here's the thing, you need to tell me the truth, because I'm gonna get a quantity amount, not just that you're positive, but I'm gonna get how much is in your system. And so I need to know when you smoked it last, so that if I find out next time it's not going down, things are gonna be worse. So when did you smoke? When did you smoke last? Day before yesterday. So that's why you weren't wearing your patch.
No, really, I just, like I said, I'm on 2 different levels. I was already done doing my first one.
Right.
Now I'm on the second one. First bill when I was on, that's when my blood pressure. I figured since I wasn't paying the bill anymore, I had to let blood pressure. They hadn't been
I know, that'd be really convenient if you had 2 felonies and you didn't have to wear a drug patch and you could smoke marijuana 2 days before court. That'd be pretty convenient, wouldn't it? So you're gonna have a drug patch today, within 24 hours. I know the first one will be positive, obviously. If the next one is not going down, then your bonds in each of your cases will be raised and you will be back in custody. No questions asked, do you understand? So you have 24 hours. I want you to get confirmation of that to your bondsman. Even though you've paid your bondsman, they're still your bondsman. They're still gonna give you, just because you paid them off doesn't mean they're not your bondsman anymore. Okay, so even if you pay off the other one, you're still out on bond. You're still required to keep in touch with them. They're the ones that'll help you figure out when your court days and all of that stuff. So don't stop communicating with them, because even though you've paid them, they can get off your bond and you can go back to jail. So keep up with everything you're supposed to. I want proof to them by tomorrow or this afternoon that you have the drug patch. You need to make sure it's switched every 2 weeks like it's supposed to. Wear it properly. There's no going in and saying, well, it fell off, and none of that.
even when I was on blood pressure, I ain't never feel no good.
Okay, well, that makes me more concerned about your decision making if you were doing well and then you decided right before court to go smoke, right? Okay, step in front of the clerk. She's gonna give you a reset notice. You need to get a lawyer hired as well before that next court date.
Fine.
Let's see, you're Deshaun Robertson?
Yes, ma'am.
And this is 25 DCCR 0914. Mr. Wilkerson has filed a motion to withdraw, correct, Mr. Wilkerson?
Yes, Your Honor.
Ms. Robertson, do you have any issue with me allowing Mr. Wilkerson to withdraw as your attorney?
No, ma'am.
All right, then I'll grant that motion, Mr. Wilkerson, and sign that order. And so, Ms. Robertson, are you able to hire an attorney?
I just got back at the hospital. I had brain injury, so I had surgery. And I just started going to work on the pharmacy
Okay, and where are you working?
at risk care. Take
So-
care of people with disabilities.
So what I'm going to do is have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. You need to fill it out accurately and completely. I'm going to take a look at it. You're going to swear under oath that it's all true and correct, and then I'll see if you qualify for a court-appointed lawyer. All right? Step in front of the clerk at the end, and she'll give you that paperwork. Thank you, Mr. Wilkerson.
Thank you.
Paper for the image more. He told me to make sure I go.
Okay, so you did that as well?
That was a condition of her bond.
Good.
And I know of no problems. with
Good.
her-
So keep doing everything you're supposed to, and keep those so that if we need them, we'll have record of that you're going, okay? Thank you, ma'am. She's good.
Thank you.
Let's see, you didn't already print that order, did you? For Wilkerson's withdrawal? Morning.
Good morning. We've emailed the attachment.
Okay, thank you. Good morning. Are you Michaela Marcantel? And will your client waive the formal reading of the indictment?
She will, Your Honor.
Let me get to it. Ms. Marcantel, in cause number 25 DCCR 0528, you're charged with the state jail felony offense of theft of property from May 28th of 2022, continuing through June 4th of 2022. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be $4,492.45 to be paid back in restitution, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Marcantel is not competent?
No, Your Honor.
And any reason
She's
not to
never been
waive?
arrested before, Your Honor. I don't
We've
have
got
an
the
objection
amount.
to waiving.
All right, Ms. Marcantel, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. I'm going to waive the pre-sentence report. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings, place you on probation for 5 years. You're ordered to follow all of the rules and conditions of probation. I'm also ordering you pay back the restitution in the amount of $4,492.45. If you do everything that you're supposed to on this probation, this is an excellent opportunity because you are not a convicted felon. You don't have the conviction on your record. And if you successfully complete the probation, at the end, the case actually gets dismissed and you'll never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sent to the state jail prison for up to 2 years. Do you understand? That's a lot of money to pay back also. 5 years seems like a long time to pay it back, but it'll sneak up on you. And so it is very important to me that you start paying back that money immediately. Even if you pay a little bit a month, it'll add up. What can happen is you can do everything else you're supposed to on your probation. And if we get to the end of the probation period and you have not paid that restitution back, and I make a finding that you could have, you could still get revoked to go to prison after you've done all that probation. Do you understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You just need to have a seat here in the courtroom. Probation, she's sitting at that desk right there. She's going to call you up when she's ready to go over all of your paperwork. Good luck to you, ma'am. Good morning, sir. You're Carnell Beard?
Yes, ma'am.
And Mr. Beard was previously in court. You entered a plea of guilty to collision involving serious bodily injury. And I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
Any additions or corrections?
No, Your Honor.
There was a notation that restitution was to be determined, but I didn't see that there was any. Ms. Malfino, does the state have any notation or request, or did I miss it?
Morin stands exposed under the judge's sharp gaze, his excuses unraveling as she confronts his marijuana used before court. Her tone hardens, her words cut deep. But the courtroom isn't done delivering shocks. New defendants walk in, each bringing fresh stories of theft, deception, and redemption waiting to be earned.
I did send Mr. Davis the complainant a restitution request form. I have
not ever heard back on it.
Okay.
So at this time, I don't feel like I have something to stand on for her.
Okay. All right, then, Mr. Beard, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 10 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. And if you do that, this is an excellent opportunity because you don't have the felony conviction on your record. And at the end of the probation period, if you're successful, the case is actually dismissed and you'll never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, you could be found guilty, and you could go to prison for up to, is it 10? I'm sorry.
Just so
20.
the record is clear, it's 20. We've
20
added
years.
to count 1 and 2.
Okay, so you could go to prison for up to 20 years if you violate your probation. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you when she's ready to go over all of your paperwork. All right, good luck to you, sir.
Thank you, Judge.
Thank you, Mr. Rojas. All right, sir, you Kelton Hebert?
Yes, ma'am.
And this is 24 DCCR 1498. What is the announcement?
Judge, if we could have 2 weeks, Mr. Hebert was not able to come to my office since our last court date. There's a particular video he needs to watch. He's been working too much, but we'll make those arrangements if we can just have 2 weeks.
Okay, so this will be the final reset. You need to figure it out. I appreciate that you're working, but find a time to go visit with Mr. Gallimore before that next court date. It'll likely be 3, just because we're down, but,
I looked at my calendar, both of those are fine.
okay, all right. Stay in touch with Mr. Gallimore. We'll see you at the next court date.
Thank you.
And then you have Duma Turner. This is Mr. Hoffpowers. Good morning, sir. You're Duma Turner.
Yes, ma'am.
And in 24 DCCR 1998, Mr. Turner, you're charged with criminal mischief. And what is the announcement?
Judge, if we could just have a normal reset on this one, not had an opportunity to review all the discovery yet.
Looks like you were just got on in August. Any issues that you see?
No, Judge, it looks like there should be an offer in there and the restitution amount has been determined.
All right, so Mr. Turner, I'm going to just do a normal reset, about 30 days or so. Make sure you visit with Mr. Gallimore before that next court date. We'll see if we can get an announcement.
Sounds good.
All right, you're free to go. Thank you.
Judge, that's all I have.
Thank you, sir. Have a good day. Good morning. Are you Thomas Fisher?
Yes, ma'am.
And Mr. Fisher was previously in court and entered pleas of guilty in cause number 23 DCCR 1046 to aggravated assault with a deadly weapon and 23 DCCR 1047 criminal mischief, a state jail felony. I've received that pre-sentence report. Has everyone had an opportunity to review that?
Yes, yes, Your Honor, we have.
Are there any additions or corrections?
No, not by the statute.
All right, sir, I'm going to find in each of those cases that you entered your pleas of guilty freely and voluntarily. Find sufficient evidence in each case to find you guilty. However, I'm going to follow the agreements in each case. In cause number 23, DCCR 1046, defer all proceedings for a period of 5 years, place you on probation. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. And then in cause number 23, DCCR 1047, also defer all proceedings and place you on probation for 5 years. You're ordered to pay the $500 fine in that case as well, and to follow all of the rules and conditions of probation. This is an excellent opportunity because you have no felony conviction on your record. And so if you successfully complete the probations, then you will never have felony convictions. And at the end of the probation period, the case will be dismissed. One of the conditions of your probation is going to be that you participate in any and all mental health services as well as drug treatment. Whatever they say is necessary, then you're going to be ordered to participate in those, whether you think you need it or not. It's now part of your probation. And so all of that is meant to help you to stay on track and do what you need to do so that you can be successful. Also, you're specifically ordered you cannot have any contact with the victim, who is Michaela Stacy. That's also obviously contact in person, but that's communication in any way. You can't send messages, you can't send anything electronically through social media or anything like that. If you do, or you're around her at all, then obviously that's a violation of your probation. You're going to be right back in here. If you violate your probation in these cases, and you are brought back into court, you could be found guilty in each of your cases. And in the first case, you could go to prison for up to 20 years. And in the second, I believe it's a state jail felony, you could go to prison for up to 2 years. Do you understand? I'm handing you in each of your cases the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. And then I will sign a dismissal in cause number 23 DCCR 1751 as part of this plea agreement. You need to have a seat here in the courtroom. Probation will call you up to her desk as soon as she's ready to go over your paperwork. Good luck to you, sir. Thank you, Mr. Macon. Good morning.
Good morning.
Good morning, sir. You're Roland Guillory. And this is 24 DCCR 1568. Mr. Guillory was previously in court, entered a plea of guilty to the lesser included offense of a Class A misdemeanor abandoning or attempt to abandon or endanger a child. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
State has to.
Any additions or corrections?
Just that I've reviewed it with Mr. Guillory. He would like the court to move forward with the plea agreement, and we understand the recommendations of until for parents and classes, and until that is completed, for him to have supervised visits with the child, and also with MHMR.
Yes.
He's tried several times. Their system has been down for quite
It
some
has.
time, but he said they were able to get him scheduled in
Okay, good.
November 11th.
Okay.
Yes, ma'am.
All right.
No additions or corrections, Judge. I do have some concerns, particularly on page 1 under the defendant's version where he says he doesn't feel like he committed a crime.
I think that's an issue as well. I think with regard to that, probably some of the other issues that hopefully we'll address on the probation, and the fact that it was reduced to a misdemeanor probably covers that, but I did have the same concern. I think I'm going to go ahead and go forward. Are you okay with that, Mr. Coleman? Okay. Mr. Guillory, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings, place you on probation for 2 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. That includes participating in the through Spinal Top and whatever the recommendations are through that caseload on probation, completing the parenting class, doing everything you're supposed to, and then not having there's no unsupervised contact with any child until further order of the court. So if you go through all those classes and you're well on your way and you're following all the recommendations and following through with Spinal Top, there may be a time where probation sends me back something that says, hey, he's doing great, we're ready to do unsupervised, but you're going to have to do everything you're supposed to. If you do everything you're supposed to on this probation, then this is an excellent opportunity because you don't have the conviction on your record. And if you complete the probation, then at the end, the case will actually be dismissed. The other side of that is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sent to the Jefferson County Jail for up to 1 year. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you up to her desk when she's ready to go over your paperwork. Good luck to you, sir.
This one will be taken care of, this one outside of down the hall.
Good morning. You're Seneca McDaniels, and this is 24 DCCR 1915. Mr. McDaniels is charged with unlawful possession of a firearm by a felon. Go ahead, I'm sorry.
Your Honor, we have an agreement in which this will be taken care of down the hall as well.
Okay.
So we can get a couple of weeks.
And he's already paid the fine, Judge. I'll withdraw the forfeiture document. He will sign it in Ms. Holmes' office, and we should take care of it before the next time.
All right, so I'll just do a normal reset. Obviously, if it gets taken care of before that court date, then you can just let him know. Otherwise, make sure you're here on that court date if nothing has been done before then, okay? All right, you're free to go.
Thank you, Judge. It'll be done this week.
Thank you. You've got a Zully Valencia as a sentencing.
Yes, Your Honor.
Morning begins with calm formality. Valerie Hill, a trembling mother, pleads guilty to driving drunk with a child in the car. Her punishment is probation, not prison, but the judge's warning lingers like a shadow one wrong move, and freedom vanishes. Then comes Christopher Moran, a man charged with continuous violence against his family. His case turns the tone electric. When the judge discovers his recent drug use, her voice sharpens like a blade. That'd be convenient, wouldn't it? She says, her authority thundering through the courtroom. The air thickens with fear as Moran realizes his choices are closing in. The pace slows only briefly before other lives enter the spotlight. Deshaun Robertson seeking a lawyer, Michaela Markell facing restitution for theft, and Carnell Beard hearing the weight of 10 years of probation that could erase or cement his felony. Each case feels like a separate universe of guilt, mercy, and second chances. But the true suspense lies not in the verdicts, but in the silence that follows each one. The courtroom becomes a mirror, reflecting regret, stubbornness, and fleeting hope. When the final defendant, Roland Guillory, stands before the bench, his denial, "I don't feel like I committed a crime," draws the judge's unease. She grants probation anyway, trusting time to teach what punishment cannot. As the gavel falls, the message is clear: justice isn't always cruel. It's conditional, and it watches, waiting to see who changes and who repeats their mistakes.